All right, so what trademark rights really mean? So, a trademark is the exclusive right to use your mark for certain goods and services. It's going to protect your name, logo, or slogan in commerce, and it does not give universal ownership of a specific word or phrase. It is scope is defined by use and registration. So, in just plain terms, what that means is that when you are looking to instill your trademark protection. You don't have broad protection. You have specific protection over your name, logo, or slogan as you specifically use it in your industry, in your nature of business. So, like I said, it's exclusive, but it's not absolute. And I thought that this topic was really important because sometimes once we have the trademark registered for our clients, they're starting to call us saying, look, we're seeing this business use the same name through social media or even on a website. And so we have to break down what are the specific goods or services that your name is protected to. And is this really an infringement on your rights, or is this just a subsequent use of the name, logo, or slogan that's in a different industry and it may not cause any sort of confusion between consumers. So, a trademark is really for exclusive right to use your mark for certain goods or services. It doesn't give you universal ownership of a word or phrase. And so it's not absolute at all. The 360 view of trademark protection. So, federal protection is when you go to the USPTO. That is the protection that we specifically offer here at the Curry Law Firm. That's the only type of trademark rights that we will file for you. Common law rights, that's when you hear people say, oh, well, I hadn't filed anything, but I had been using it. And so, those are your common law rights. Maybe you hadn't taken the actual action of filing the trademark with the USPTO, but you have been using the mark for 5 years or 10 years. And a lot of times for our older business owners, they've been in business 10 years or 15 years. Trademarks weren't that big of a deal as to where people were thinking about getting them. I would say a lot of people, 10 or 15 years ago, we really saw this massive spike in people start to apply for trademarks during COVID time. A lot of people were taking the time to learn during that time. People were being able to join different clubs and Clubhouse. I don't know if y'all remember Clubhouse, and just really learn through different videos, through whether it was TikTok or whether it was Instagram. And it helped people learn and broaden their perspective of what it means to be a protected business owners. And that's how trademarks really start to spike, is because people then begin to learn about it. And so sometimes we have business owners who maybe do have common law rights, but they actually need to take a further step of registering those rights with the USPTO. Now, states do offer state trademark registrations, but we do not handle those at all. It really doesn't provide much protection for the business because it only offers you trademark protection in the specific state that you are located in. If you're located in California and someone who is in the state of Maryland is using the name that you have trademarked, that state registration doesn't offer you any sort of protection versus the USPTO protection. It provides you protection in all 50 states. So if you have a registered trademark with the USPTO and you're located in California, they're located in Maryland, you can still send them a cease and desist letter, or you can still enforce your rights, just because you're in two different states. The USPTO protections, they spread to all 50 states. And then you have international protections. There's something called the Madrid Protocol that allows for a registration that you have with the United States Patent and Trademark Office to be recognized in different countries and continents. As long as you first register with the United States, you can then take that trademark registration and apply for it to be recognized in different continents or in different countries. Where they do accept this. So they have to, number one, they have to also accept the Madrid Protocol. And then number two, you have to make sure that you're already registered in your country of origin. And so for here, it would be the US. So that is a cool way that if you do have a consumer base in other countries, that you can go ahead and enforce those rights in those other countries. So Specificity of trademark rights. These rights are limited to the specific goods or services listed on your application. So it's very important to make sure that your application is conclusive of the goods or services that your business is offering now or intends to offer in the near future. Are the goods similar services? They can also be protected if consumers might think they could come from your business. For example, if your business offers apparel, it can be common that you may also offer some sort of accessories. Like if you sell clothing, it's common that a business that sells clothing might also sell any sort of like belts or bags, something of that nature, things that are related in the types of goods or services. Now, unrelated issues, industries, there shouldn't really be any sort of infringement risk. And so that's where I talked to you about in the beginning, where some of our clients may say, hey, this business is using the name that we've trademarked. The first question we need to look at are, what are the goods and services listed on your application? And then, is this related to the industry that you're in? Because if it's unrelated, then there's no infringement risk and it's not anything to be concerned about. So, trademark classes explained. The USPTO has something called classes. These classes, there's 45 of them, and they make up the description of the bulk of services or goods that people would offer and want protection in connection to. So, that could include clothing, which is class 25, or certain types of accessories fall under class 16. Certain types of professional services, such as legal services, can fall under class 45 versus like entertainment and use of a specific name for social media use, such as vlogging or blogging. That would be under class 41. And I give these examples to tell you that each number is associated with a specific service or product that people typically offer and want protection as it relates to that specific service or that specific product. And so the trademark classes are what are used to be able to determine, what do you actually do with the item that you're trying to trademark. For example, Nike, right? They have trademarked the word Nike, their logo, which is the swoosh symbol, and their slogan, which is just do it, as it applies to clothing. And their biggest thing that they're known for really is apparel and footwear. However, if you were going to put on a track meet and you were going to call it the Nike Classic, it's very likely that because Nike offers athletic products and athletic gear, that people would expect that if it was an athletic event, that it would be, and it was called Nike, that it was put on by the actual Nike corporation. And so when you are looking to determine, are the industries related in some nature, some form of fashion, you really want to think about, would a consumer think that these would be related based on the types of services or goods that are being offered. So the goods and services are classes that divide goods and services by type. Picking the right class is critical to your protection scope. The wrong class could mean that you have weaker rights and you have more exposure to people infringing on the rights that you do have. So we really want you to think about not just what you use the mark for now, but what you intend to use it in the immediate future. Choosing the right classification. So you want to start with conducting a search. The USPTO puts out this free manual called the USPTO Trademark ID Manual. You can literally go to any sort of online search engine such as Bing or Google, Safari, and type in USPTO Trademark ID Manual, and it will probably be the first or second link that comes up, and it should be affiliated with the handle uspto.gov. So that's important to look for. Does it end in .gov.gov? And that's most likely the USPTO link that you're going to want. In that link, it's going to have a search bar in the middle of the page, and you can type in one of the goods or services you offer. So maybe it's tax preparation, right? That's the main service you all offer. You type it into that search bar, and what this trademark ID manual will tell you is the exact group of class that your specific services fall under. And it'll also show you all these different subcategories that you may want on your application. So maybe it's tax preparation services, tax preparation consulting services, tax preparation services for veterans, or it can go into very specific groups or niche areas. And so you want to make sure that you are selecting the items that are most applicable to the business that you conduct and the types of consumers that your business actually serves. And so you want to think not just what do you sell today, but what do you plan to sell soon? And I say this because, when you submit a trademark application, you have specific rights as it applies to the goods or services that are directly listed on your application. If they're not listed on there, you don't have protection over just all the categories of products. And so I use Walmart for an example. When Walmart was first started, they were created as a retail store. They had no idea that they were going to offer curbside service or delivery services or an online marketplace, right? Those are things that came after. And so once they decided to offer additional services, they had to apply for new trademark protections. So that means they had to file new trademark applications as it applies to these new services that they were now going to offer, curbside, delivery, online marketplace, things of that nature. And so when it says, what do you sell today, but what do you also plan to sell soon? We want you to be mindful, not in the not in the far future, but only in the immediate or near future, because when you submit to the USPTO that these are the services that you want to be connected with your specific trademark, or these are the products, they're going to ask for proof, right? They want to see that you have actually taken the steps to start to market or advertise your mark as it relates to these specific services or products. So you will have to show proof. So if it's not anything that you're going to have up and running, I'd say within 6 months, then now's not the time probably to put that on your application. You may want to come back later, or you can split your application in two, almost, where you are able to claim that once one group of services that are listed on your application you offer now, right? You already sell them today or advertise for them today, and this other group you're not quite offering, but you intend to offer it in the near future, and that's the intent to use. And so you can do it that way, where you can have one class, say it's class 25 for clothing, you sell that now, but in the near future you want to offer some sort of consulting, and so you're going to also apply for class 35, right, under the intent to use category. So that's also an option. But when you are doing this search initially and before you've submitted the application, you want to consider overlap, right? The broader your filing is, that means that you try to keep the description of services or products as broad as possible. It's not really good if it's not accurate, right? You want to be specific and consider if the goods overlap with another class. For example, you don't want to put just clothing and think that if you saw the name and it's already trademarked for accessories, that you could use it for clothing. We talked about already that it's very likely that a business that sells clothing would also sell some type of accessories. And so it can be very common that someone who is using, the name Ralph Lauren for the sale of clothing would also like to offer some sort of accessories or maybe any sort of home good products such as towels, right? Or linens. And so that's what that means. Consider overlap. Is it likely that businesses in your industry would also offer services in another group or another class of products or services? And has anyone trademarked the name or logo or slogan that you want to use for those other classes that cover similar services or products, right? Because that could also cause a likelihood of confusion. Maybe they're not specifically registered in the class that you initially looked at, but is that class related to other categories or other classes that could cause a likelihood of confusion? So here's an example. The word Brewhaven trademarked for coffee shop, right? That's class 43 for cafe services. You say, I really, really want to use the word Brewhaven for my business. I had no idea that this whole coffee shop even had trademarked the name Brewhaven, but I do see it online. But I don't want to have a coffee shop. I just want to sell coffee beans, and that's in class 30. So I should be good, right? We're in two different classes. We're going to be doing different things. Wrong. That isn't a great example of overlap, right? There's a likelihood of confusion. Think about Starbucks, right? Think about the big brand names that you know. Starbucks is a coffee shop, but does Starbucks also have their coffee beans for sale? Yes, we see them for sale in Starbucks and even on shelves at grocery stores or at any sort of like convenience store. So, those are the types of things when we say overlap, that's what we're talking about. So different classes are not automatically a safety zone. Just because you see it trademarked in a different class than what you may want to trademark it in doesn't mean you're always safe. You need to consider if there's room for any sort of overlap there. So here's the likelihood of confusion test that we recommend you use. Number one, mark similarity, right? Is there any sort of similarity of the marks, including the appearance of the mark? So the way that the word appears, the way that the logo appears, connotation, the way that consumers comprehend the word or the phrase, sound, right? When you say the two words, do they sound similar? And then pronunciation, right? Does it sound the same? So sometimes people are like, oh, well, they spell their go G-O, but I want to spell go Geaux. We're down south. So it's very common for people to do that. Those two words sound the exact same, right? In consumer understanding, they know that Geaux still means go, that is what it's meant to mean. And so that can cause a similarity of marks there. Now, goods and services that are offered, just because you find that the name, logo, or slogan that you want to use is already trademarked, is it trademarked for the exact goods or services that you want to offer, or any goods of services that are similar? And so we just gave an example of what that means when we mean similar. Do they overlap in the type of industry that you're in? Channels of trade. Where are the goods or services sold, and where are consumers looking to buy your specific products or services? Would that be the same channel of trade for another mark that you see that's already registered or has a prior pending application to you? And then what's the strength of your mark? How unique is it? Is it unique, or does it merely describe the services or products you offer? These are some of the things that you want to consider when you're looking at the likelihood of confusion test. Ultimately, consumer confusion is likely to lead to infringement. Before we even file a trademark application for our clients, one of the biggest things we're looking for is called likelihood of confusion. So we run this test on the mark that you present to us that you want to trademark, whether it's a name, logo, or slogan. And then we go ahead and do research and see what we find out there through the USPTO database, through searches through online search platforms, searches through social media, searches through domain handle ownership. We're searching all of those areas to really see, do we see any sort of potential for likelihood of confusion? Because ultimately, for us, that is the most difficult item to overcome once the trademark office is reviewing your application and trying to determine if they're going to approve your application for the next stage. Likelihood of confusion is very difficult to overcome. The second most difficult thing to overcome is merely descriptive. Does the name that you are wanting to trademark merely describe the services you offer? Are you going to offer cell phone services and you're going to call your cell phone company cellular? Right. So those are the things that we look for the most. And so these are the types of tests that you can start to consider when, number one, you're looking to see if the name that you want to use or the logo or slogan you want to use is available for use based on what you see out there. And number two, if you already have a registered trademark and you see some sort of use and you're trying to figure out if it is infringing on your rights or not, go through these tests and really figure out if there's any sort of likelihood of confusion there, because that's what a court would ultimately consider, as well as the USPTO, if you were going to try to oppose, any sort of similar application. So, strong versus weak trademarks. A strong trademark is something that's unique and distinctive, something that's a coined term, such as Xerox or Google. These aren't necessarily names that have an exact definition, but we definitely know these names as they pertain to the specific services or products that that brand offers. Something that's weak is going to be a generic or a descriptive term, such as best coffee shop. That is just a descriptive term. There's no unique factor to that. There could be many best coffee shops, right? And so the reason that the USPTO is hesitant to offer trademark protection over generic or descriptive terms is that when you have trademark protection, you're preventing someone from being able to use that specific name or term as it applies to your specific industry. And because best coffee shop are very generic terms, they wouldn't want to prevent any coffee shop from using it outside of the one that has trademarked it if it's not anything that's unique, right? A trademark really should be unique because it should directly pop into people's mind, when they hear your brand or see your brand, whatever it's a logo, a name, or a slogan, and directly related to the services or products of your specific brand. When you hear best coffee shop, you may think of, oh, best coffee shops just in Houston or best coffee shops in Los Angeles. There may not be any sort of one specific brand that comes to mind. And so a trademark is really meant to provide protection over a specific brand and the specific services or products that that brand offers. So it's not meant to be generic or broadly descriptive. Stronger marks, they equal better protection and easier enforcement. Common law versus federal rights. We briefly hit on this, but the important thing to remember here is that both need continuous use to maintain. So, common law is limited to your geographic area. We talked about some of those business owners that have had the business for 10 or 15 years or so, and now they want to claim common law rights because someone else is trying to utilize the name and they don't have it trademarked. They may try to enforce common law rights, but that could be restricted to your geographic area. Federal rights is nationwide coverage. So if you have a registered trademark with the United States Patent and Trademark Office, that gives you federal protection. And that is very, very broad protection over all the states, right? So when you think of state protection, it's just including your state. But when you think of federal, it gives you more of a broader reach because it gives you protection as applies to that name or logo or slogan being used in all 50 states. And then, like I mentioned before, once you have federal protection with the USPTO and you do business in other countries or continents, you can take this as proof to them to be able to get your trademark recognized over there. And also, registering expands your reach and enforcement power. So, if you are looking to expand your business past the state that you're in, or just with e-commerce, it makes it so easy for many people to be able to find about your business. And maybe you're local, right? You all only offer real estate services in Los Angeles, but you have people who follow your page, all the way in Connecticut or Rhode Island or something. You still don't want them taking the ideas and unique things that you're doing and copying that and building up a brand that resembles something very similar to what you've built. So that's why it's super important to be able to get your trademark registered with the USPTO so that you have federal protection. So, what exactly are trademark owners' legal rights? We put so much stress on getting a trademark, and then you finally get it, and you're like, okay, so what does this mean? And I get that from clients a lot. Okay, so what does this mean, and what do I need to do next? So, a trademark owner's rights include exclusive use of the mark for your goods and your services. You can stop others from using confusingly similar marks. You have the availability to file lawsuits or oppositions for somebody that may be using your mark in an infringing manner. That you have not granted approval of them to use. And then it also gives you the power to license, to assign, or to sell your trademark. So maybe someone wants to use your mark. They're like, hey, I do understand that you have the trademark protection over this specific mark, but I am interested in using it. Can I license the rights to use it? It's almost like a lease, right? So trademarks are a form of property, intellectual property, right? And real estate is a form of property, but it's real property. The same way that you can lease out land to someone, you just let them use it for a specific time period or for a specific use. You can lease out your intellectual property rights to your trademark and allow someone or a business to be able to use your trademark for a specific, service or a specific product for a specific time frame, things like that. So it's really cool in that aspect that It is a piece of property that you can license, assign, or sell. Rights in action and enforcement options. So you have the right to be able to enforce your rights with something like a cease and desist letter or something like USPTO opposition or cancellation proceedings. Now, for some people, they're like, okay, well, I don't know if I necessarily want to, enforce my rights and send someone a cease and desist letter and tell them they can't use a name. But that is part of being able to uphold the trademark protection that you have. Now, you don't have to do it in a mean way. You can definitely do it politely and you can try to figure out a way to work with them. Maybe they're going to be able to license the right to use the name from you instead of just telling them they can't use it at all. But it really is important that if you do have a registered trademark, that you take the steps to enforce your rights. So this could include cease and desist letters, USPTO opposition or cancellation proceedings, platform takedowns through things like Instagram or copyrights for like I have a couple clients where that's all that they hire me to do is I submit the trademark infringement and copyright infringement claims to Instagram and to TikTok to be able to take down pages that are utilizing their brand name and their slogan that are registered and trademarked with the USPTO or that are infringing on their copyright rights to videos or any sort of graphics that they have individually created, photography that they've taken, and someone's using it without their permission. I go ahead and show this proof to Instagram, to Meta, to TikTok, and they will remove the necessary page or the specific post or video. And so federal litigation or infringement is probably like the furthest step you'll take. But you want to try other methods to be able to get through to infringers so that they can stop using the mark that you have taken the time to build up, the brand that you've taken time to build up, and the trademark rights that you do hold as a trademark rights owner. So, what are some of the remedies for infringement if someone is using your mark and they're refusing to stop? Number one, you can seek an injunction with the court to stop their infringing use. And that's essentially the court saying, hey, you have to stop doing this, right? You're infringing on this specific trademark owner's rights, and we need you to stop immediately. You can claim damages. This could be monetary damages and lost profits. They can have to pay you for their use if they are truly infringing on your rights and refuse to stop. Recovery of attorney's fees. If you had to hire an attorney to represent you in any sort of trademark infringement matter, then that can also be grounds for a remedy for infringement. If you had to go to court or you had to send a demand letter, then you can recover attorney's fees in some cases. Destruction of infringing goods. So if someone was making a product that infringed on your rights, this happens. Nike has pretty much all of their main shoe designs trademarked, right? For trade design. And so if someone is utilizing their mark or their designs without their permission, they could ask the court that that infringing party destroy all of the products so that they cannot keep selling those infringing products and cannot keep profiting off of the trade design or trademarks of Nike without their permission, because they shouldn't be able to financially benefit off of something that Nike has built and Nike has created. Use it or lose it. So I cannot stress this enough. It is very important for you to, number one, continue using your trademark once you have a trademark and enforce your rights. So non-use of 3+ years equals abandonment. And I've seen in certain instances where someone filed a trademark application and there was found the USPTO said, oh, this is likely to be confused with the mark that's already registered. They went and found proof that the retail store had closed down in the specific mall that they said they were located in, that they no longer operate business, and that the LLC filings were, extinct, right? They were no longer in use. And that was grounds for them to be able to get their trademark application approved because they were able to prove that the other party had essentially abandoned their rights. They're no longer using it. And so someone else should be able to use it. So you can't just get a trademark and think you're going to be able to hold on to those rights forever. The whole idea of trademarks is meant to protect brands that are actively in use in commerce. So you need to maintain evidence such as ads and packaging and invoices to prove that you are still using that specific mark or that specific logo or slogan or phrase in commerce. Renewing your trademark is equally as important. So, between years 5 and 6, you do have to file a declaration of use. Please, please, please beware for any sort of solicitation that will get sent to you in a text message or mailed to your address on file with the USPTO. Probably they're starting to do it around year 3 and 4, saying that you have to pay, X amount of dollars in order to renew your trademark. No, you only need to do this with the USPTO between years 5 and 6 from your initial registration date. And that communication will come via email from the USPTO or in the mail from the USPTO. So make sure that if you are receiving anything in the mail telling you that it's time for you to renew your trademark, that when you check who it was sent from, that it has the actual USPTO seal and it says United States Patent and Trademark Office. That's the only office that should be asking you for money to renew your trademark. Otherwise, it's likely a solicitation, and you should look somewhere on that page and probably the very smallest print or font that you can find on that page. And it should say something like, this is a solicitation, this is being sent by a non governmental entity, something of that nature. All right. So then every 10 years, you need to renew your registration. Missing deadlines can actually get your trademark canceled. So between years 5 and 6, if you do not file that declaration of use and show proof that you are still using that mark in commerce, they will cancel your trademark and you'll have to start over from scratch. And someone else at that point could have put in an application before you. And so you just want to make sure that you are actively using your trademark, enforcing your trademark rights, and renewing your trademark. Enforcing your rights can include also monitoring your brand online and in the marketplace, making sure that no one's infringing on it that way, sending timely cease and desist letters, oppose confusingly similar applications at the USPTO. Public vigilance equals continued protection. So the more that you continue to use your brand and your mark out there, the better protection you have. For some of my clients, sometimes people who just simply follow their social media page or are consumers are the ones who notify them like, hey, someone else is actually using your slogan or your logo. I saw it and they're offering almost essentially the same services you are, the same products you are. You may want to check this out. So the more that the public becomes aware or familiar with your specific brand, the better protection you're going to have, because then even your consumer base or your social media or online followers can start to alert you of infringing use of your specific mark. So, for best practices, we want to make sure that you register your trademark early and in the correct classes. You're monitoring the marketplace regularly for any sort of infringing use. You document your brand use and have proof of it via ads or any sort of invoices, and that you enforce politely but consistently. So, if someone's not responding, you need to get an attorney, you need to get legal force in there and do something about it, right? You need to be consistent with it, because you don't want someone saying that you didn't properly enforce your rights and therefore, you didn't uphold your trademark rights. So work with counsel before expanding or licensing. I've listed our contact information below so that when you are looking to enforce these best practices for strong protection, you can definitely reach out when you have those questions or when you're ready to maybe decide that you do need that extra legal protection to assist you. Thank you all so much for attending. If you have any further questions, please feel free to reach out to our office. This is a list of services that we do offer in addition to trademark services. So we do estate planning, not just for you as a person, but also for your business. That's called business succession planning. What happens to your business if you can no longer run the day-to-day activities? Or what if you want your business to continue, but you realize that your kids or your heirs just are not in the place in life to be able to run the day-to-day management of the business, but you still want them to be able to financially benefit? we can set that up through business succession planning, right? And create a business trust as to where the benefits from your business and the profit from your business can still go to your heirs, go to your children without them having to be responsible of the day-to-day managing of the business itself. We also represent people in civil litigation, whether that is a trademark infringement case or a business dispute or even probate. We do civil litigation, we do business law, and we do real estate law. Well, thank you all for joining. I know that you all have to get back to work. Your lunch hour is running low. But if you have any questions, don't hesitate to reach out to us. Thank you all for tuning in. And if you have other topics that you want for us to be able to discuss in upcoming webinars, please let us know. Send a message, send an email, and we'd be happy to discuss those topics. Enjoy the rest of your day.